Welcome to On the Mark. I'm your host, Howard Mark Rubin. I am so excited to present this podcast series addressing our rapidly changing world and how it is affecting industries and people in unique and interesting ways. As John F. Kennedy once said, change is the law of life, and those who look only to the past or present are certain to miss the future. The business leaders and personalities who I will be interviewing in these podcasts certainly look to the future. And I hope you come away with information and inspiration that helps you adapt in both your business and personal lives. You can find these podcasts on all major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, getsplatzer.com. Welcome to On the Mark. And we have an exciting episode today. I think a lot of people will find very interesting. Hopefully, they don't want to have it in their personal lives, but with our divorce rates being what they are and have been in the past, it's something that you want to have knowledge about and information. And with us today, we have Michael Stutman, who is one of the most prominent matrimonial lawyers, family lawyers, whichever one you want to use, in New York. Has been doing this for a long time, knows everything there is to know and about this area of the law, and has managed to excel in all areas of matrimonial practice. Was a past president of their bar association. So welcome, Michael, to On the Mark.
Thank you, Howard. Nice to be here.
So the what we're going to talk about in general terms, initially, eventually, but I want to ask you some questions first, is how the matrimonial law practice has changed over the years. You've been doing this for a while now, and during your time of practice, I think we've had some discussion. There's been changes in how the laws have been enforced, how maybe there's been changes in the law. But let me ask you some questions about situations that are before a marriage takes place. For instance, let's talk about prenuptials for a minute. Now, a lot of times I find that a prenuptial is caused because one party is in a family business and the family business wants to protect the assets from the other spouse, the person who's getting married, who's part of that family business, is in love and doesn't really want to even bring it up to the spouse because they'll feel they'll be insulted. And it becomes a very sore point when one party has a lot of assets and one party doesn't have a lot of assets. What's been your experience on how it's best to handle a prenuptial agreement and whether people should get a prenuptial agreement?
Well, the short answer is very carefully.
Okay.
It's always a delicate situation, particularly if you have opposing counsel who is similarly aware that the goal of the entire exercise is to make sure that the couple gets married. You don't want to be the one who blew up the marriage if you can avoid it. So you're trying to thread the needle of protecting something that does not belong and should not belong to the new spouse with a sense of fairness. There needs to be some opportunity to create marital property that is shared by everyone. It's not one of these what's mine is mine and what's yours is mine. And whether you do that by allowing the non-titled spouse to have some level of participation in the value of the business, or whether you set a schedule out at the outset that says after a certain number of years, if the marriage is not successful, the non-titled spouse gets X, and after more years, some sort of graduated participation, or there needs to be a minimum contribution to the marital pot, because if you are withholding all of your separate property, your interest in the business, and you are then spending all of the marital property to just maintain the lifestyle, at the end of the day, there's nothing left. And most people would consider that to be unfair.
Can you put a provision in I call it a prenup agreement, whatever you want to call it, where the people are in different religions, and you want to put in there that so long as you convert to my religion, or so long as the kids are raised solely in my religion, you get X. But if you don't do that, then you forfeit and you're getting a much lesser amount. Can you do that, or is that against public policy?
Well, sorry, insofar as the children are concerned, that that won't go anywhere. You can put it in the agreement, but it's completely unenforceable. In terms of having an agreement where the incoming spouse or one of the spouses will agree to adhere to or convert to a particular religion, I don't see any public policy against that. It's just a matter of what is the penalty box for the failure, and how does that ripple through if you do have children, with the dispute that will likely come up where one side says, I want our children to be raised X, and the other side says, no, I don't want either. I don't want any religion, or I want, some other religion. I haven't found with the younger couples, frankly, that religion is such a big deal as of late. It was a much bigger deal 10, 15, 20 years ago. But I'm not hearing much about that these days. Maybe, I was going to say older couples, it could be a consideration, but they're usually past childbearing age. And it's a discussion that they have. And it's kind of a binary discussion, you either will and we'll get married, or you won't and we won't.
So a lot of my clients are family-owned businesses. They're successful. They have their children in the business. And my experience has been a lot of times prenups are driven by the successful parents' family looking to protect their assets more so than the person. And what they're also looking for, if the marriage doesn't work out, they don't want to have to give all of the financial data that would normally be available. Can you speak to the issue of, can you limit financial disclosure in the event of a matrimonial lawyer later on down the line in a prenuptial agreement? Can you say that you're going to get X and you have no right to look at how the company is doing because it's a privately held company?
Well, basically what you do is you carve out the family business from the marital pot. You say this is just not going to be subject to division. It's not subject to valuation. Okay. I think you also put confidentiality terms in the prenuptial agreement. You make sure that any documents that get exchanged don't go past lawyers, accountants, or people who sign off on the non-disclosure agreement. And the only inroad that someone might have into, generally speaking, how the business is doing is if the issue of child support comes up, because child support is income driven. And so if there is a credible allegation that the payor spouse is being underpaid, or is somehow or another involved in some level of chicanery in the business, you may have a difficult time walling the business off from some sort of an inquiry. But it takes more than someone just coming in going, I think my husband's a crook. Okay, you got to come up with something where, say you've got a 1040 tax return where they're reporting $50,000 of income, but they're flying around on net jets. They've got houses in St. Bart's and Bermuda and Florida and wherever. And if you've got that kind of foolishness going on, you're not going to get a very willing ear from a judge saying, this is intrusive and burdensome and invasion of my privacy, stuff like that. So as long as you're dealing with your cards face up, usually you can protect the business from that kind of otherwise searching and intrusive and what we call a proctological examination.
Yes. So let's talk about changes in the law. Now, it used to be that if one spouse walked in on the other one in bed with another person, and there was clear information that one's cheating on the other, that would have some significant impact on a divorce. I think the law has changed as to that. Can you address what the present law is and how it's changed as to fault, the issue of fault, and how important fault is, or doesn't fault ever come into play in a marital situation?
Well, about 15 years ago, there was an interesting coalition between those of us at the American Academy of Matrimonial Lawyers and the people who were feeling very protective of victims of domestic violence. The people who were concerned about the victims of domestic violence wanted to get rid or wanted to add a no fault basis for a divorce. Because until that time, you could only get divorced in New York if you could establish fault. And fault, the longer the marriage, the more you needed something akin to blood on the floor in order to establish fault. But you had, adultery, cruelty, abandonment, and constructive abandonment. And the victim of domestic violence, while you could, of course, prove cruelty, you had to get to the courthouse to do that. And in order to get trial time, and a defendant could demand a jury trial on the issue of fault in a divorce case, it was a real problem for them. We in the Academy hated a concept called enhanced earning capacity, okay, where there was, if you went to medical school, if you got married and you were a truck driver, and you then went to medical school and you came out the other side as an orthopedic surgeon, the difference between what you earn as an orthopedic surgeon and what you would have earned as a truck driver was subject to a calculation that established a present value of your career based on your future earnings. And you would have to pay your spouse some proportion of those after-tax dollars. And it was horrific because it was basically nonsense. And so the Academy and the domestic violence people got together and said, well, I tell you what, we in the Academy will support your no-fault divorce, but you support us in getting rid of this enhanced earning capacity and celebrity status, and celebrity goodwill and things of that nature. And the legislation got passed in 2010. So we killed two birds with one stone. And now, and for the last 15 years, if somebody wants to get a divorce, you can't stop them. New York was the last state in the union to get there, and we finally got there. We beat back the fault-based divorce was basically promoted by, I think, religious factions, and we finally got the legislature to agree. So you don't need fault to get divorced, and frankly, most judges don't want to listen to it anymore. So if you come in and say, he was messing around with somebody or she was messing around with somebody, the judge will go, yeah, okay. But there's no economic penalty for that kind of fault unless you've been using a lot of marital money in pursuit of your extramarital interests. So if you take money out of the marital pot and buy your boyfriend a house in Amagansett, okay, that will fall into play. But if you've got yourself a boyfriend or a girlfriend and you take them out to dinner every so often, we're not going to spend lawyers' time at $1,000 an hour chasing down a $250 dinner tab.
How about other kinds of fault? How about like if there's an allegation that one spouse is being beaten by the other, would that enhance what that the victim spouse, assuming they established it's a victim, would get in a divorce proceeding?
To the extent that a judge has discretion, it will probably lend the court to exercise its discretion in giving more than less in a range when they've got a range of possible outcomes. So, for example, maintenance is what New York calls alimony. We have a statute that says that if you've been married for 0 to 15 years, you're entitled to get alimony for a period of, I want to say, 15 to 30% of the length of the marriage. So you come in as a victim of domestic violence, I'll bet you the judge is going to go closer to 30 than to 15. Plus, you do have a separate cause of action for assault and battery. You've got the tort claim that you can either bring inside the divorce case, and then the judge will either hear it in the divorce case, or the judge will sever it and say, you go try your tort claim someplace else, but you can do that.
That's interesting. I never. A judge can hear a tort claim separate from the divorce and make a monetary finding on a tort claim other than the matrimonial claim. I was frankly unaware of that. That could happen.
Yeah.
And
Yeah. So if you divide up the marital assets, say you've got $1 million marital assets, and everybody gets 500,000, okay, and then you get a verdict against your other spouse for $300,000. He or she will have to pay you that $300,000 out of their $500,000.
And that would be a separate proceeding before a matrimonial judge. He would hear that sometimes.
The matrimonial judge could hear it. Most of them don't. Most of them will cut it out, and most of them, and it's just as well because they don't handle personal injury cases. You saw a real spike in that kind of claim for sexually transmitted diseases, whether it was the papilloma, the HPV, or whether it's a herpes virus of some sort, whether it was AIDS or something. The key is, of course, you've got to prove that you got it from him or her. And that might not be easy because it is not uncommon if one person is out exploring an extramarital relationship, so is the other.
Okay, so let me ask you about, other than divorce, I know there may be more, but I know of 2 other ways that people can separate. One's annulment and one's by a legal separation. There may be others, and you'll discuss that. But when would a person go, and what's the advantages of doing an annulment? And when should someone look at doing a legal separation rather than a divorce?
Well, an annulment is something you should pursue very quickly if that's what you want to do. Most people look at an annulment because there's some sort of psychic income that they get from declaring the marriage void. Because generally speaking, and I don't want to get in the weeds too much about it, but generally speaking, if the marriage is declared void, then of course all of the benefits that you would otherwise get by virtue of having been married in the first place, you're not going to get. So you don't want to go there. A legal separation was a tool that was useful in the days of fault-based divorce. But with no-fault divorce, if you're not going to get the other side to agree to maintain a legal separation, the only way you're going to get that is by an agreement. Because if you started an action for a legal separation, the other side could just counterclaim for divorce, say our marriage is irretrievably broken, goodbye. Now, why would a couple agree to a legal separation? Because with a legal separation, you can execute a settlement agreement that whacks up the property, that determines who's going to take care of whom and for how much, who's going to pay what debt. You get an estate waiver so that if somebody dies, the other side doesn't inherit, can't mess up the estate. With a settlement agreement, you are basically as divorced as a person who's divorced, except you can't get remarried. Okay, you can't get a qualified domestic relations order to divide up certain types of pension plans. You still have to file a tax return as some species of married. It's either married separate or married joint. Oh, and health insurance, of course, the big one. Most health insurance plans are family plans, and when you get divorced, you're not part of the family anymore. And so someone may not be able to get the same type of coverage after the COBRA period expires as they would if they just stayed in the marriage. So the calculation for legal separation really, it's only 2 or 3 moving pieces, and most people will just say, well, we'll just get divorced.
Is it at this point in the court system, do you see many actions for annulment or for legal separation, or is it really something that's a dying breed that you don't really see much of that anymore?
No, they are real anachronisms now.
Right.
I'll see pro se. You see a pro se litigant try it sometimes, and they're usually unsuccessful because they still think that you can't get divorced without fault or something. And once they understand what's going on, people will usually get divorced.
So when should a person, they have a marriage, they don't know whether they want a divorce, they're thinking about it, at what point should they consult a matrimonial lawyer? Should they wait until they've made a decision that they want a divorce, or should they consult someone at an earlier stage?
Well, I think we add a certain amount of information. If someone's not sure as to what they want to do, they should understand the consequences, or either the benefits or the burdens of doing that. And so I would say at least once a week. I'm usually talking to someone who says, I'm not sure I want to stay in the marriage. What would happen if I didn't? And it's not you can't drill down into the minutia, but you can give them a pretty big picture and a good idea of what happens to property, what happens to support, who pays whose counsel fees, and how long does it take, how expensive is it, and where do the children fall into this? Most people, once they find out about the difficulty that children play in the dissolution of the marriage, they'll generally think twice
Right.
before they decide to blow it up. Plus, you realize that in New York City, I mean, even if you're making $1 million a year, most people. I had a client once in a deposition said to his wife, he says, "You just don't understand. We all live hand to mouth. It's just a matter of at what level." So, no matter how much money you make, if you're going to try and support 2 separate houses with two separate, places with the same amount of money, everybody's standard of living is going to drop pretty significantly. 2 houses, a couple of private schools, and a vacation, and and income taxes, and you've run through a big income. So
let me ask you a question. Let me ask you a question.
Go ahead.
I don't know if you're going to want to answer this question, but if you don't have to answer this question. It's supposed to be in the law that the husband and the wife are equal. So in terms of custody decisions, particularly, they're both, I think, treated equally. I've always felt, and maybe that's changed over the years, that there's always a preference when it comes to child custody that the wife gets preference from the courts I don't know if this is whether it's a legal. I think it's not a legal issue. It's the way that the courts just kind of ruled. Is that fair to say, or is that your experience?
My experience is that that pendulum has swung pretty hard in the direction of 50-50. I mean, you start with a presumption that the parents are each equally entitled to
Right.
make decisions for their kids, so-called legal custody, and spend time with their kids, so-called physical custody. And in certain respects, depending on the county that you're in, you may find some bias in favor of one parent or the other, particularly depending on the age of the children. Okay, you get, for example, an older boy who's in sports and debate team or whatever, and the father's been the one who took him to the games. The father's the one who's the assistant coach. The father's the one who's really dialed into the kid at that age. Okay, he is going to probably be listened to pretty significantly in terms of the amount of time that he wants and his involvement with the child. On the other hand, you have, younger children, and mom is the one that is taking care of the kids on a day-to-day basis, and it's more of a leave it to beaver type of household. You're going to get the leave it to beaver kind of view from the court. But I've got a very hotly contested custody case going in, of all places now, Missouri. And even Missouri, the presumption's 50-50. So it's, I think with a very, very young child, an infant, of course, mommy can play the breastfeeding card. Daddy's, working or whatever. You get very young children. I think mom may have a leg up to some degree. But like once the child is in preschool, so-called preschool, and is not in the house 24 hours a day, or there's a nanny involved, the parties have like a live-in nanny, there's no reason why each parent shouldn't be able to have the kid with him or her as much as the other, so long as you can really do it. I mean, I've had people come to me, both men and women, who work in the financial world, okay? And they're out the door at 7 o'clock in the morning. They're at client dinners at night. They're trading foreign currencies. If they're trading currency in Asia, I mean, their hours are ridiculous. And they say, I want 50-50. Now, in what universe are you going to do that?
Yeah.
How are you going to do that? And they sit and think about it and they go, you're right. And I said, I get it. I get it that you don't want to be marginalized in the life of your children, but the way to do that is to partner up with your soon-to-be former spouse and try and get it done without a lot of acrimony, and he or she will be very supportive of you. So you try and put it together.
What do you do in a situation, which I'm sure happens often, where divorces have an impact on the child, on the children, and a child says, I don't want to see the other parent. I'm angry with the other parent. I don't like going to their house because they have a girlfriend there, or that I don't have my own room, or for whatever reason. And the child is saying, I don't want to go see my father. It could be the other way around too, but I don't want to go see my father. How should the parents handle that kind of a situation?
Well, first of all, the parents need to handle it together if it's going to get solved. And oftentimes when you've got what we call a resist refuse situation, it's a situation that is being fomented by one of the spouses. And if you've got that going on and you don't get to it right away, as they say, that horse will leave the barn and you're not going to put it back in.
Right.
It's a very, very sad, difficult situation. But if you can either get the parents on the same page, or you can see it happening, you can anticipate it happening, and you can get the attention of the court, there are methods of everything from, making the parties engage with a mental health professional to actually taking the child away from the alienating parent or the estranging parent and saying, you're not going to have this child. You're not even going to see this child for a number of months. And the child is only going to be with the other parent, and there'll be all kinds of draconian measures put in place. But at the end of the day, the courts are not a good place for solving that problem. We don't move fast enough. We don't have the tools for it. I mean, I'm just a lawyer. I've got 4 kids of my own in various states of disarray. I mean, who am I to tell you what to do with yours?
Do courts order that the children or the parents go for psychiatric, psychological help on issues like this? Can the court order, and do they order? Because as you said, they're not really equipped to deal with these kind of things. Can they order that type of relief? And do they?
Yes, they can. And I don't know you well enough, Howard, to know whether you've spent any time on the couch, but like I have. And I know if I was told that I got to go there, I'll sit there with my arms folded and say, you can't make me talk. You can make me go, you can make me show up, but coercion is just never going to work well. What you do get, and what the court can do, is order a psychological forensic investigation, which involves psychological testing and interviewing and stuff, and you get an opinion from either a psychiatrist or a psychologist in terms of how the children will be best served in a parenting arrangement between these two parties. And aside of being frightfully expensive, it is very intrusive, and a lot of people, when they see that specter coming down the road, they'll get smart, and they'll say, and they'll pull back from their very antagonistic positions. But if you end up in a real live custody fight, you are going to incinerate hundreds and hundreds of thousands of dollars, and you're going to say things that the other side is never going to forget. It's a terrible way to solve that problem.
We live in a world that social media is becoming part of everyone's life. You and I are a little older, and we didn't grow up in a social media world. How has social media affected matrimonial practice and the people involved?
Well, first of all, it provides a wonderful source of evidence. I mean, it's just a gift that keeps on giving. Whether it's the Instagram posting or Facebook chatter or text messaging back and forth, but more from the social media standpoint, it's just wonderful information. It can show, here, look at Daddy having a great time with his children in Puerto Vallarta and playing baseball and cheering Johnny on or whatever. Or, oh, look, there's Mommy with her skirt pulled up, drunk under the Christmas tree again. Okay. I mean, so it's the problem with it now with AI is going to be authenticating this stuff. How do you get it in an admissible form before a judge? And it's between being able to make up telephone numbers and to make pictures and videos and stuff, it's I think it's going to be a greater problem than not. The other feature, of course, of social media, and is something that we address in going back to the subject we had initially, was we address it in prenuptial agreements, where there are confidentiality agreements, there are NDAs, and there are penalties for posting information about the other side or their family or the family's finances and stuff. And I have yet to litigate one of these liquidated damage clauses in a prenup, but that's only because I haven't had anyone come to me and say the other side's violated it. So maybe just the prospect of getting nailed is enough of a preventative feature. But we do that, and then the other feature of prenups, and I'm just going to kind of go off your script for a minute, that I'm a big fan of, and I mentioned this before about how difficult it is to get court time, is that we're starting to build arbitration clauses into our prenuptial agreements. You can't do it for custody. You can't do it for child support, but you can do it for just about everything else. And that's another way to perhaps maintain a level of privacy, because of course an arbitration is not a public forum. There are, and I'm sure you're well acquainted with the downside of arbitration. I mean, your arbitrator can just go off the rails, and you don't have much of an option. We've been floating the idea of not only a private judge, which is just, I think, a synonym for an arbitrator, but also maybe engage in a private appellate bench for people that are wealthy. We have a number of retired judges who came off the bench, and they have to come off the bench at like 70, 72. Some retire after a certain number of years of service, because if they die and they haven't retired yet, their spouse won't get their retirement fund. It's called, the death gamble. And so we have plenty of candidates to create a private appellate bench to oversee an arbitration. But we're just kind of thinking about that right now. I'm not sure how that would work. I don't know what the appetite for the private sector is for that. But
well, how about the use of mediation? Mediation meaning it's not binding, but you can have the same type of a judge or an arbitrator who's acting as a mediator. And do you find that in your practice? Do you find that's helpful to get someone to come in and say to both sides? Because when we're talking about division of property, particularly division of physical property, there are certain rules as to what everyone gets. We don't have enough time for you to go into all of the complexity of how property is divided, but in the ways to reach that settlement, do you use mediators? Do you think that's a helpful tool?
Yes, we use them. Yes, they can be very helpful. Yes, there are a couple of good ones. There are also a couple who, you're kind of wasting your time. The court rules now have a requirement of presumptive mediation in matrimonial cases. You can opt out of it if you want to, but it can be hugely helpful, particularly if you've got a mediator that everybody respects. And again, we have a lot we have a roster of retired judges who can be very, very good at mediating. 3 of my partners are certified mediators. I am not. It's just not my wheelhouse. I'm an advocate. I negotiate and all that, but I'm not. I tend to see. I'm more comfortable advocating for one side of the story than telling people that, well, they're nice people on both sides.
I've had at one time a partner. I'm not involved in matrimonial work, but I think it's very important, the attorney that you get, because some attorneys are looking to be conciliatory and reach a resolution, and to get the client is going to be usually very emotional and wants to kill the other side. And a lot of they're very angry. And I know in this case, I had an attorney who I was working with at the firm, and what he did was he would do the opposite to his client. He would say, "They're saying you're lying. Don't let them get away with that." And they'd get them riled up, and it would increase the legal fees. It would increase the amount of money that the parties are paying. And because the attorneys themselves, if you're not an ethical attorney, and I know that you would never do this, and I know that you're ethical, but there are attorneys out there that encourage the clients to do more litigation because it helps them. Maybe it's their personality. What do you do if you get an attorney on the other side who you know is just trying to fire up his client, and it's not really in the client's interest? It's not in the interests of the family or the kids. How do you deal with something like that?
Well, I mean,
don't tell me it doesn't exist. I know attorneys who are like that.
I'm not telling you. There are plenty of people out there who make a lot of money feeding red meat to their clients.
Right.
You know, and it is the thing is that most of those people are not only known to us, but they're also known to the court. They know that these people are nothing but troublemakers. Maybe it's because they're so insecure that they just can't get to yes. Every word out of their mouth is no, 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 no. And so I think the thing that you do when you've got one of those people on the other side is you do not engage in an appeasement of them because you give them $1, they'll want $5. I think you get into the courthouse as quickly as you can, and get a judge to put at least a layer of sensibility over the dispute resolution. You put a timeline on it, where things have to be accomplished within a certain period of time, and you get the case done. Because what the people selling red meat are good at doing by saying no, 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 is attenuating the process, making you make motions because they're not complying, and the way you get them to comply is to not only have a court order that tells them they must do what they were told to do, but also get the other side to start paying your legal fees. But you know, there's some lawyers who've made a terrific business being aggressive, being sharks, being Roy Cohen. I mean, you know, and people who want that will always gravitate towards that. That's not our go-to place. You know, that is not our knee-jerk response. But by the same token, I don't think we'll ever be out-lawyered by anybody else. So,
well, for those of you out there that need matrimonial advice or assistance, Michael is I know from experience, not that he's represented me, but for clients, is a terrific guy. Will give you good advice and will guide you through the process in an ethical and in a way that's in your best interest, because I don't believe in taking the red meat approach. Any of the parties except the lawyers benefit by that. So, Michael, I'd like to thank you for being a guest today on the Mark. I think you've given some great advice to people, and I hope to speak to you soon. Thank you very much.
Thank you, Howard. It was wonderful being on with you. And I may say it was interesting for you to say that we are sort of dinosaurs with respect to social media, but here we are.
Here we are, right. With that. Thank you.
I hope you enjoyed this episode of On the Mark. I started this podcast by quoting John F. Kennedy and would like to end it with quoting one of my favorite baseball players, Nolan Ryan. Enjoying success requires the ability to adapt. Only by being open to change will you have a true opportunity to get the most from your talent. I wish you success in staying ahead of the curve instead of behind the 8 ball. Thank you for tuning in.